Swayam Prabha. Digital India. Educated India.
A of IPC is to be taken as Section 85 and 86 of BNS, and Section 494 of IPC is to be taken as Section 82 of BNS.
Hello all, this is Professor Shivani Goswami and I am teaching in IP University. Today I will be dealing with my lecture 2, and that is on marriage and nullity. In the previous lecture, that is lecture 1, we had started with the Hindu Marriage Act, because I am dealing with Hindu law. So I had started with Hindu Marriage Act, and we talked about the jurisdiction of Hindu Marriage Act. I talked about section 1, and I stated that it is applicable throughout India except for the state of Jammu and Kashmir, and it is also applicable to people who are living outside the territory of India. We talked about section 2, that's on whom Hindu law applies, because I had already stated that there is no definition of the term Hindu. So we do it by saying that these are the persons on whom Hindu law apply, and we come to conclusion that they are Hindus. So I talked about Hindu by religion, Hindu by birth, those persons who are not Muslim, Christian, Parsi or Jew and on whom Hindu law applies. And we also, apart from this, we also discussed about section 3, that was a definition clause. We talked about the customs, we talked about Sapinda relationship, prohibited degrees, certain terminologies like half-blood, full blood, and then uterine blood, sisters and brothers, sisters or brothers. And we also talked about the sources of Hindu law. I told you that it is divided into 2 parts, the ancient and the modern sources, and in that we had discussed the different type of ancient sources and modern sources. And finally, I talked about the 2 schools of Hindu law, that is the Mitakshara and the Dayabhaga school of Hindu law. Now today that was there in lecture 1. Now we will be proceeding further. We had discussed it till section 4, the Hindu Marriage Act. Today I will be talking about the marriage and nullity. This is my lecture 2. And to begin with, when we talk about marriage, we are all aware of this term marriage. Now we usually talk about that, in a layman's language. Companionship is the basic requirement, and that is why the institution of marriage, it came into existence. Earlier, there was no as such this concept of marriage, and the primitive man was more into satisfying his essential needs, and as a result of which he did not focus on marriage and all those things. But later on, this institution started developing, and earlier it was confined only to their particular tribe only, and a person was not allowed to have sex outside his tribe. Later on, the possessiveness and everything developed, and as a result of which the institution of marriage came into existence. When we talk about marriage, it plays a very among Hindus, when I am talking about, it plays a very pivotal part, it plays a very significant and noteworthy part. Why I am saying so is because usually we say that marriage among Hindus is a sacrament. It's a sanskar, though now we usually say that it's a blending of both sacramental and contractual part, with slightly bending towards the sacramental part, but usually we believe that amongst Hindus marriage is more of a sacrament. So when we talk about this marriage, we know that it's an oldest institution, and where the father of the girl gives her hand to a noble man, which we usually consider, and that is the husband of that woman. Now, the Hindu Marriage Act, section 5, it's a very important section, and it basically talks about the essentials of valid marriage. If we go through this section, I'll be just reading it, and then I'll try to explain what is it. Section 5 of the Hindu Marriage Act, 1955, lays down the condition for Hindu marriage, and it states that a marriage may be solemnized between any 2 Hindus if the following conditions are fulfilled, namely, neither party has a spouse living at the time of marriage, At the time of marriage, neither party is incapable of giving a valid consent to it in consequence of unsoundness of mind, or though capable of giving a valid consent, has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and procreation of children, or has been subject to recurrent attacks of insanity. It further goes, the bridegroom has completed the age of 21 years and the bride the age of 18 years at the time of marriage. The parties are not within the prohibited degree unless the custom or usage governing each of them permits of a marriage between the two. And the last one is, the parties are not subpenda to each other unless the custom approves of the same. Now, if we go through it, bifurcate this section, it has 5 major components. Number 1 is that we believe in, after this, I told you that Hindu Marriage Act 1955, it came on 18th May 1955. After this act, after this date, under the Hindu Marriage Act, we believe in monogamy. So that means bigamous marriage and polygamous marriage among Hindus are totally proscribed, they are totally prohibited, they are totally forbidden. And before 1955, although a person could go for a number of marriages, but after the act came into operation, it is monogamy that is the rule. That is one man and one woman at one time. Second, we could say that it's mental disorder. Third is the criteria of the age, which it talks about, because it says that the boy should be 21 years of age and the girl should be 18 years of age during the time of marriage. Fourth and fifth, it talks about the prohibited degree and the subpenda relationship, which I have already discussed in my lecture 1. Now, when I start with the essentials of the valid marriage, the first is monogamous marriage. That means, as far as this particular section is concerned, it basically talks about 3 things and they are all dealt under this thing. The number 1 is it talks about void marriage, it talks about voidable marriage, and when we talk about 21 and 18, it talks about valid marriage. So that means the 3 types of marriage, valid, void and voidable, are being there itself under section 5 of the Hindu Marriage Act 1955. In the case of monogamy, that is the first clause, we know that monogamy, subpenda relationship and prohibited degrees, they are all part of section 11 of the Hindu Marriage Act, and which deals with the void marriage. That means no marriage in the eyes of law. So these 3 clauses, which are also there under section 5 on the essentials of Hindu marriage, are also present under section 11 and they are coming under the heading of the void marriage. That means 3 things: void marriage, subpenda relationship and prohibited degrees. They are, if you go for this, these kind of marriages, they are totally void, they are totally no marriage in the eyes of law, because now we are after monogamy. And secondly, the parties should not be within prohibited degree, and the third, they should not be subpenda to each other in order to make their marriage a valid marriage. The second part, which talks about mental disorder, it is coming under section 12 of the Hindu Marriage Act, which talks about voidable marriage. So that's a part of voidable marriage and it's there under section 12 of the Hindu Marriage Act. When we talk about the third one, again it's the criteria of age. Earlier it was considered to be with the Child Marriage Restraint Act, which was also called as the Sharda Act. The child marriage was considered to be completely a valid marriage, but with the coming into operation of Prohibition of Child Marriage Act 2006, which is presently applicable amongst the Hindus, such kind of marriage is considered to be now a voidable marriage. And this particular Prohibition of Child Marriage Act, it talks about certain provisions which I would be dealing it later on. When we talk about the first clause, that is the monogamy. So that means monogamy is one man and one woman at one time, one man and one woman, I mean to say husband and wife. Right? So that means in case of the amongst Hindus, after the act has come into operation, it is one husband and one wife at one time. So that means if a person during the subsistence of his valid marriage, he goes for another marriage, this second marriage is bigamy, and it is totally void ab initio. It is not leaving like that. Further, it says that if a person goes for bigamy, he or she would be prosecuted for bigamy under section 494 of the Indian Penal Code. So that means the punishment is also provided if a man or a woman, it is applicable to both, goes for second marriage during the subsistence of a valid marriage. When we talk about valid marriage, I mean to say that all your ceremonies, everything need to be performed, and if no ceremony is performed, or you are falling within prohibited degree, or you are falling within the subpoena relationship, that marriage is not considered to be a valid marriage. Now let's take an example here. For example, A and B, they are a married couple, and the marriage is valid because they have performed essential ceremonies of marriage. Now, if this person, say the husband A, he goes for another marriage with a woman C, this second marriage between A and C is void marriage. Why? Because number one, it's a case of bigamous marriage, and number two, his first marriage with woman B was completely a valid marriage because all the ceremonies, everything which needed to be complied with for essential of the valid marriage, they were actually complied with. And if this person goes, then the women of this person, because here it is the aggrieved person is the wife of that person, she could move to the court and prosecute her husband for bigamy under section 494 of Indian Penal Code, and the punishment is there of 7 years imprisonment and fine. That was a case of valid marriage. It might happen that nowadays we see that there are so many couples who are living in live-in relationship, which we could not even envision a few years back. But now live-in relationship is in vogue, and without undergoing any ceremonies of marriage, nothing of that sort, the couple, the man and women, they are living together. Now in this case, that means there is no marriage that has taken place. You are just living like husband and wife without performing the ceremonies of marriage. And if during that time, if this person, say A, who is a boy and B is a girl in this live-in relationship, A leaves this woman B and goes and solemnizes his marriage, say to C, maybe the parents have put pressure, something like that, then here it's a case of this person. The first, the live-in relationship was not a marriage. So, he could not be prosecuted for bigamy because that first time when he was living with a woman like that only, without solemnizing the essentials of valid marriage, that was not a married couple. So, in a way, this marriage is now the first marriage, and it's a legally wedded, and this woman is a legally wedded wife of that person, and he could not be prosecuted for bigamy by the first live-in woman to whom he was living with. Then, howsoever you might be serious, for example, say, if the persons, a boy or a girl, they fall within prohibited degree and they start living together, say they are brother and sisters, and they start living together, and howsoever they might be serious towards each other, and they start living like a husband and wife, that would not make a couple a husband and wife. Why? Because here they are falling within the prohibited degree, and I have already told that if you fall within prohibited degree, your marriage is no marriage at all, that marriage is totally void ab initio. So any one of them can leave and solemnize a marriage, and this second marriage, this person could not be prosecuted for bigamy because it's not the case, or actually not a case of second marriage. So that's not a case, and this person would not be liable for that thing. In this case, the nullity could be filed. The section itself says that it has to be filed by the parties to the petition. So that means it's only the boy or a girl who can file a petition for nullity. If at all second marriage takes place, the wife of this person, who's actually a wife of this person, can move to the court and apply for injunction under Specific Relief Act. She could also move for divorce also, but maybe on the ground of adultery, because adultery is the ground for divorce, or judicial separation, which is mentioned under section 10, and divorce is mentioned under section 13 of the Hindu Marriage Act. But she could move for injunction and so on. But the petition for nullity has to be filed by the parties to the marriage only. Then that was a case of monogamy. Second is mental disorder, and it states that that's a case of avoidable marriage, which comes under section 12 of the Hindu Marriage Act also. It states that if a person is having a mental disorder to such a capacity that he is incapable of giving a valid consent to the marriage, or even if he is capable of giving a valid consent to the marriage, but he is incapable of procreation and he is not fit for marriage, or he is suffering from recurrent attacks of insanity, then also, it's a case of avoidable marriage, and it falls under section 12 also of the Hindu Marriage Act. Earlier, epilepsy was also there, but now it has been repealed. Now it's only the case of insanity. The third essential ground for the valid marriage is the criteria of age. I've already stated that the boy should be 21 years of age and the girl should be 18 years of age at the time of marriage. Earlier, Child Marriage Restraint Act was there. Now it has been repealed. It has been taken place by this Prohibition of Child Marriage Act 2006. Now, this age is an essential requirement under it. If a girl is less than 18 years of age and the boy is less than 21 years of age, then we consider it as a child marriage. But under the provisions of the Act, now it's a case of a voidable marriage. Earlier, child marriage was considered to be a valid marriage, but now under this Act, it's considered to be a voidable marriage. So that means till the time it is annulled by either party to the marriage, it is completely a valid marriage. The power of annulment, of course, is given to this boy and the girl, and the 2 years' time is given to them under the Act from the time when they attain this majority, this age criteria, and they can get their marriage annulled. So that means after 18 years, the woman will get 2 years and the boy will get after 21 years, 2 years for getting their marriage annulled. If they do not annul their marriage, that marriage is completely a valid marriage. For voidable, the thing is that until and unless you annul, it's completely a valid marriage, and for this you need to go to the court also. The provisions of the Act, it also talks about that as far as the girl child is concerned, if she is less than that age, then the maintenance, everything, residence has to be provided by the boy's side. If the boy himself is a minor, then it has to be provided by the father of the bridegroom. Then if you have children from this kind of marriage, then the custody has to be given. I mean, if child is below 5 years, and we know that it is always the welfare of the child that is paramount, and seek the welfare of the child below 5 years, tender years, it is obviously the child is given to the mother, and later on the welfare is seen and the child is given to that person where his welfare lies. Then there are certain marriage prohibition officers also. If they do anything bona fide and they are not liable under this particular Act, punishment part is also there. If a boy is, he is above particular age, say he is above 18 years of age but below 21 years of age, again he is punishable. The punishment is also provided under the Act, and it's 2 years, and fine is also there. If you any person who instigates it or provokes that kind of, the punishments are provided under Prohibition of Child Marriage Act 2006. So that's an act. Basically it's 18 and 21. 18 is for the girl and 21 is for the boy, and annulment is allowed within a period of 2 years from the day when you attain this particular ages, as I have mentioned. Then I have already talked about subpenda relationship and prohibited degree. In my first lecture, I had also explained it with the help of a diagram as to that two parties should not fall within prohibited degree. If at all, you need to have a valid marriage. So that means if two persons, that means a boy and a girl, if they fall within prohibited degree, that means they are coming within the range of 3 on maternal side and 5 on paternal side, and they are subpenda to each other. And if they are subpenda to each other, their marriage is totally void ab initio. Then another thing which is to be noticed, I'll be talking about the custom this thing later on. There are certain things, because I've already told in my previous lecture that it's 3 on the maternal side and 5 on the paternal side, and in order to constitute a valid marriage, you should not be subpenda to each other. Only then the marriage can be valid, otherwise it is void ab initio. And then prohibited degree is the last ground in essentials of valid marriage, and specifically talks about that you are not allowed to marry such and such persons. If one is a lineal ascendant, the wives of lineal ascendant and descendants, then children of two brothers, children of two sisters, children of brother and sister, your, it could be grandfather's brother, mother's brother, on both the sides, whether it is paternal or maternal, you are not allowed to marry these persons. And if at all you go for marriage with these persons, that marriage is void ab initio. That marriage is not allowed in the eyes of law. There's a case also, Srimati Shakuntala Devi versus Amarnath, and here it was laid down that marriage within a prohibited degree is void ab initio until and unless the custom approves otherwise. Now, I'll try to explain here. I had already stated in my lecture 1 that if your customs, your usages, everything, if they are inconsistent with the provisions of law, the custom has to go away. If any law is inconsistent with the provisions of this Hindu Marriage Act, it has to go away. So that means it is the provisions of the Hindu Marriage Act which is now applicable after 18th May 1955. But in the places where explicitly, specifically, it is elucidated, it is mentioned that until and unless your custom approves of the same, so that means here they are giving importance to the custom. So in whether it is Sapenda relationship, whether it is prohibited degree, although such kind of marriages are not allowed, but if you see Hindu Marriage Act, it specifically says that until and unless your custom approves of the same, then it is okay. Normally, Sapenda relationship, if the parties are within Sapenda relationship, the marriage is void ab initio. But if the custom approves of the same, that means it is allowed. So even if they are Sapenda, and the custom is, because the custom is approving, then also it is going to be considered to be a valid marriage. Similarly, if you fall within prohibited degree, generally it is void ab initio. Exception is your custom is approving the same. So that means here custom is overriding the sacred law because it is explicitly mentioned under your Hindu Marriage Act. So if the custom is approving, it's okay. Here also, for example, let's take an example. In South India, the marriage between maternal uncle and niece is valid. Now, if you go to South India, you will say that they are coming within prohibited degree. How come their marriage is valid? But their custom is approving the same. It has been continued for ages without any breakage. And I had already told what are the requisites of the custom, essential customs. So, because it is approving, so that means their marriage is a valid marriage. I am talking about monogamy again and again, that after Hindu Marriage Act, monogamy is the rule. One man and one woman at one time, that is one husband and one wife at one time. But there is this thing of chadar odna, in the sense that in Haryana and Punjab, after the death of the brother, if he has a wife and the younger brother is also married, there is a chadar odna ceremony, and this woman is also considered to be the wife of the younger brother because the elder brother has died. If we say so, we say that no, it is not monogamy, it's bigamy here. But because their custom approves of the same, so that is the reason it is both the wives are legally wedded wife of that person and it is approving the same. When we come to sections, that was section 5, which was a very important section. The next section is section 7 of the Hindu Marriage Act. I'll just read it and then I'll explain it to you. Section 7 mentions about the ceremonies of Hindu marriage, and it says that the ceremonies, I've already told that for a valid marriage, ceremonies they are very essential, they are very pivotal, they are very noteworthy as far as Hindu marriage is concerned. Now, we talk about the Shastric ceremonies, we talk about the customary ceremonies. Now, in the case of Shastric ceremonies, we usually considered Kanyadan, Pani Grahan, Vivaha Homa and Saptapadi. They are considered to be the 4 significant Shastric ceremonies, and where Saptapadi is there, that is 7 steps around the fire, here one of the most essential ceremony, and if it is there, it has to take place. If it doesn't take place, that marriage is not considered to be a valid marriage. We may take an example. For example, a marriage is going on and there are it's a very lavish party, and the boy and the girl, that means the bridegroom and the bride, they are exchanging garlands. And after garlands, when they have exchanged and people are eating food, every dance, reception, everything is going on. And after that only the bomb blast. There are so many terrorist activities, you never know what happens, and the bomb blast take place, and as a result of which now everything is devastated. So that means in this particular marriage, no sapadi has taken place, which we call as 7 feras, that is 7 steps around the fires. So no sapadi has taken place. So now here it is, and that was a mandatory requirement. So even though you have exchanged the garlands, that will not come under that's not a marriage, because when sapadi is there, it has to be performed. If it is not performed, then the marriage is not a valid marriage. Until customary ceremonies are also there. For example, among the santals, smearing of vermilion is allowed, and there is no sapadi, that is, there is no 7 steps around the fire, but because their custom approves of the same, so that is considered to be a valid marriage. So it could either be shastric or customary. Shastric, 7 steps are there, sapadi is there, that is most important requirement, and if it doesn't take place, that marriage is no marriage. But if your custom approves of otherwise, then that is allowed, because the custom says so, and that can take place, and that would also be considered as a valid marriage. For example, among the Sikhs, they do not take 7 steps, they take 4 rounds around that thing, Guru Granth Sahib. That you cannot say that its marriage is not valid because they have not taken those 7 steps. Their marriage is also valid marriage because their custom approves of the same. So if the custom is there, that is allowed, that is equally applicable. But if sapadi is the requirement in your this thing, then that needs to be performed, and that is mandatory. Darbara Singh case, Karewa marriage, it was considered to be legitimate kind of a marriage. Bhaurao Shankar is another case where a person was married to a woman, Indubai, and then he later married another woman, Kamlabai. But because he married this woman and this woman filed for bigamy, it was laid down that no essential ceremonies have taken place. There was no sapadi, nothing of that sort. So this is not a marriage, as a result of which this person cannot be held liable for bigamy under section 494 of the Indian Penal Code, and thus he was exonerated. So he was not held liable for bigamy because no ceremony had taken place and no ceremony was performed in this kind of marriage. Then 17 of it talks about the punishment. Already told that it's monogamy that is the rule. If you go for another woman during the subsistence of your valid marriage, your wife is alive, if she has died, then you can go for another marriage. That's not an issue. Or if divorce has taken place, then also you can go for another marriage. But if nothing of this is there, for example, your wife is there, it's a subsisting valid marriage, and then you go for another marriage, you are performing the ceremonies and all those stuff, then you could be held liable for bigamy and you could be prosecuted under section 494 of the Indian Penal Code. Or it could be also be that the husband or wife of a person has died, then also this person can go for the marriage. That is allowed because he has already died and you're going for that marriage. That would not be considered a bigamous case. Now next is again a very important section, that is section 9 of the Hindu Marriage Act, restitution of conjugal rights. It states, when we read this section, it says that when either the husband or the wife has without reasonable excuse withdrawn from the society of the other, the aggrieved party may apply by petition to the district court for restitution of conjugal rights, and the courts, on being satisfied of the truth of the statements made in such petition and there is no ground why the application should not be granted, may decree restitution of conjugal rights accordingly. Explanation says, where a question arises whether there has been reasonable excuse for withdrawal from the society, the burden of proving reasonable excuse shall be on the person who has withdrawn from the society. Now, again a very important section. We know that in the beginning of this presentation, I had stated that after marriage, you require society of your husband or wife, as the case may be. You require the conjugal relationship has to be maintained. You want companionship of your spouse. But due to some reason, maybe not some reason, because under restitution of conjugal rights, the requirement is without the consent and without any reasonable cause. If any of the spouses, it could be husband, it could be wife, if they abandon your society, if they leave your society, they withdraw your society and move apart, then the aggrieved person, which could either be the husband or the wife, as the case may be, can move to the court and apply for restitution of conjugal rights. You want to restore, you want your husband or wife, as the case may be, to come back. So this remedy is available to both the spouses. It could be the husband, it could be the wife, and only the aggrieved party moves to the court. Obviously, when you have withdrawn from the society, you cannot move. It is the other party who has been withdrawn that will move to the court, that's an aggrieved party, and they will apply for restitution of conjugal rights, because they, being a married couple, they would require each other's society, they would require each other company, they would require each other companionship, and if any one of the spouses, the husband or the wife, they withdraw it, and it is without the consent of the other party or without any reasonable cause, then the court is going to see that thing and they will restore back their conjugal rights. That is the marriage rights. So we have a number of requirements. The first is the petitioner could either be the husband or wife. Respondent withdraws from the society of the petitioner. Withdrawal of the society has been made without any reasonable cause. The petitioner should file a petition in the district court. The court to be satisfied with the truth of the statement and finds that no other reason is there for denial. Burden of proof of reasonable excuses on the respondent. Relief of restitution is available to both the parties. Now, the first requirement is that it could be either husband or wife. Now, when I say husband or wife, again I mean to say that there should be a valid marriage between the parties, right? Valid marriage means essential ceremonies, which I had talked under section 7. It needs to be performed. You should not come under void marriage, which is there under section 11, and all the ceremonies need to be performed, and only the relief is available only to the married couple. So, if it's not a married couple, for example, it's a live-in relationship couple, a live-in couple, you are just living like that without getting married, the relief is not available to such kind of partners. This cohabitation is not allowed. It is available only to the married couple, and it could be available to both the parties. It could be either the husband or the wife. So they can move to, if the wife has withdrawn from the society, the husband can move. If the husband has withdrawn without reasonable cause, without the consent of the wife can move to the court and apply for restitution of conjugal rights. Now, so that means validity of marriage is the first requirement in order to avail this remedy, this legal succor of restitution of conjugal rights. Then, there are certain cases where it has been laid down that you need to have a valid marriage, only the married couple can be performed. These are certain cases. The second component is respondent withdraws from the society of the petitioner without reasonable cause. Now, by restitution, I do not mean to say that even if you are living in a turbulent marriage, you need to be with your spouse only. For example, the husband is very alcoholic, he is very brutal, he beats you, he is very cruel towards you, he is forcing his pure vegetarian wife to cook non-vegetarian food and to have also that non-vegetarian food. Now, these are certain things which are exceptional, and if you cannot now here force a wife to live with this brutal husband. So here, if the wife withdraws from the husband, withdraws means withdraws from the society of the husband and goes elsewhere, and if the husband doesn't have the remedy to file the restitution of, because he cannot force his wife to come, the wife has a reasonable ground, she has a reasonable excuse to leave her husband and to move elsewhere. So she has those grounds. So in order to avail this remedy of restitution of conjugal rights under section 9 of the Hindu Marriage Act, it is necessary that you have withdrawn when your spouse is moving out. He or she, if she has a valid ground to move out, you do not have this remedy of restitution of conjugal rights. But if that person is moving without any reasonable cause, then obviously you can move to the court and claim this remedy of restitution of conjugal rights. There are certain illustrations. For example, I have already told that if the husband is very brutal, he is very violent, alcoholism as such is not a ground, but if he is a drunkard, he drinks every day, and he drinks, and then he becomes brutal, and it is affecting your health, then it becomes something exceptional. Extramarital affair of these days, it's very common. If your spouse it could be either the husband or the wife, as the case may be, they are indulging in extramarital. He has a reasonable ground to move away from this person, and this person doesn't have any remedy in the court to go for restitution of conjugal rights, because this spouse has a reasonable ground to part ways from this person. So if the wife has an extramarital affair, the husband can move out from the society of the wife, and vice versa. Then there are other also, you are being nagged by the parents, extravagant nature, misdemeanors, unnatural offences. It could be rape, it could be sodomy, it could be bestiality. Then also the person can move out, and this person has a reasonable ground to leave the society of his or her spouse. Then refusal to have sex without any justification, again, is something which is extremely cruel. The cruel nature, of course, it is there. So these are the reasonable grounds where any of the person can move out of the marriage and the other party doesn't have any remedy, because these are reasonable grounds. Similarly, there are certain cases where the court did not find justifiable grounds. So it could be alcoholic nature, which is unaccompanied by the bad temper, accusation of bringing less dowry. Now these are considered to be normal wear and tear of married life. So if it's a normal wear and tear of married life, then the court is not going to interfere in that particular thing, because these are considered to be part of everyday's life. And if a person says that he has moved out because of this reason, which is not so grave and weighty, that is not which is justifiable, and he or she would have to move back. And if the aggrieved person, he files that restitution of conjugal rights, this person has to move back and to be in the society of that aggrieved spouse. Using filthy language in public places, again, it's not that much grave and weighty. So these are certain illustrations which have been decided in certain cases where the court had laid down that they are normal wear and tear of married life and they are non-justifiable. These are the grounds which are non-justifiable grounds. So if these are the grounds, then you cannot claim that you have a reasonable ground to move away from your spouse, and so that's not considered to be this thing. Now this again is very important. In today's scenario, we see that we talk about egalitarianism, we talk about right to equality under Article 14 of the Constitution. We have so many fundamental rights available. Now, and nowadays, women are also working. Like men, they are also educated. They are, in some cases, they are more educated, they are earning very well off, they are rolling in money, they have a very prestigious jobs and so on and so forth. Now, if at all, due to job reasons, due to these reasons, if the parties are staying at different places, and God forbid if something bad happens between the couple, and then you are withdrawing from the society of each other, the question here is, can the husband force the wife to leave her job in another place and join him back in order to just avail his restitution of conjugal rights mentioned under Section 9 of the Hindu Marriage Act? Earlier, the court did not take progressive view, they were very regressive, and they used to say that no, it's the duty of the wife to be obedient, to be loyal, and if the husband is able to provide food, clothing, shelter, the wife should leave her job and should come back to her husband and stay with her husband because of restitution of conjugal rights under Section 9 of the Hindu Marriage Act. There had been cases like Tirath Kaur's case, then Kailashwati vs. Ayodhya Prakash case, where the court had taken regressive views and they wanted here that the woman should leave her job which was elsewhere and she should come and join her husband because of this legal remedy that is available of restitution of conjugal rights. However, in now, case has been there like Swaraj Garg cases there, and Ketinov cases are now coming up, where it has been laid down that even if, you cannot force, because we are talking about equality, we are talking about parity, we are talking about egalitarianism. Now, in this era of equality, you cannot compel one person who is equally educated, who is equally, rather in some cases more educated and earning more than the husband, to leave job just to be in the society and cohabitate, just to live with her husband, because just to restore his conjugal rights. You cannot compel that person, because we believe in equality. We have our fundamental right under Article 14 of the Constitution. So this thing cannot be compelled, because then we will not say that it is equality. How can you say a person who is equally educated, who is equally earning well, who is at par? And when we talk about, there shouldn't be any bigotry or disparity between male and female, so you cannot compel one person, one gender, to leave that job and just to fulfill what is there mentioned under section 9 of the Hindu Marriage Act, that is restitution of conjugal rights. The jurisdiction lies, district court is the one who decides such cases. And when we talk about the burden of proof, the initial thing is the petitioner has to say that he has been withdrawn from the society, is an aggrieved person, and then if he has discharged his burden, it is on the respondent to prove that whether it was a reasonable cause or it was not a reasonable cause for his or her departure. So that's the case of burden of proof. When we talk about the constitutional validity of section 9, we usually talk about 3 landmark cases under it. That's T. Sarita, Harvinder, then there's the Harvinder Kaur, then it's Saroj Rani case. Now, in the first case, T. Sarita case, when we talk about this constitutional validity, it was stated that section 9, it is something which is violative of Article 14 and Article 21 of the Constitution. How can you tell a person that he or she should leave job, and when you're talking about, it doesn't talk about equality. So that thing should not be there. And how can a woman be at the disposal of another person, and she doesn't have any choice of her own, and she's totally dependent on that. Her body becomes vehicle for reproduction of, and so on. There were certain things that were laid down under it. So, in Harvinder Kaur case, the Delhi High Court had laid down that, as far as this remedy of restitution of conjugal rights is concerned, we should not bring family law cases under constitutional law. And this, the basic purpose is that there should be reconciliation between the parties. They should reconcile. And since sex plays a very important part after marriage, so it's just for restitution of these conjugal rights, and they should be together. But however, in Saroj Rani case, the Supreme Court had laid down that when the marriage has broken down beyond all repair, you cannot correct it, it's incorrigible, then there is no point in retaining that empty shell. Now here also the parties did not cohabit, and the women had applied for restitution of conjugal rights, and after the decree was passed, the husband did not come to women for a period of 1 year, and after 1 year he applied for divorce. The plea of the women was, and he was granted divorce by the High Court. Now when the case went to Supreme Court in appeal, the plea of the women was that all this thing was done to entrap her, in the sense that he had already thought of that he would not obey with the decree of restitution of conjugal rights, and then he'll become entitled for divorce after a period of 1 year, and so all this thing was there. But the court had stated in this case that this is such a kind of marriage, it's an empty marriage now. There is no point in retaining this empty shell when the marriage has broken beyond all repairs. So this thing cannot be availed. So that was the reason, and it has stated that it has broken down, and there was no use in keeping them together as husband and wife. Now next I would be talking about void and voidable marriage. Slightly, some points I've already discussed earlier. I have talked about that section 11, it talks about void marriage, and section 12 talks about voidable marriage. Void marriage, again 3, which we had discussed under section 5. Bigamous marriage is a void marriage. Polygamous marriage is a void marriage. Second is the parties, if they are subpenda to each other, it's a case of void marriage. The parties, if they fall within prohibited degree, it's a case of void marriage. So in any case, if such kind of marriage is taking place, then that marriage is no marriage in the eyes of law, and it is totally void ab initio, that is void from the very beginning. In the case of void marriage, sometimes it is said that because it is no marriage right from day one, so the parties need not even go to the court. It's no marriage at all. You can leave at any time and you can go and solemnize another marriage. These are certain cases relating to it. For example, Daljit Kaur, the court laid down that if the husband enters into second marriage without dissolving the first marriage, the second marriage is null and void. It's invalid. Then the court laid down the legally wedded wife has got a right to file a suit. And second and third, I have already explained Sapenda relationship and prohibited degrees. So I will not explain it here because I have already explained in my lecture 1. Next is voidable marriage. It comes under section 12. I'll be just reading it and then I'll explain it. Any marriage solemnized whether before or after the commencement of this act shall be voidable and may be annulled by a decree of nullity on any of the following grounds, namely A. That the marriage has not been consummated owing to the impotence of the respondent, or that the marriage is in contravention of the conditions specified in clause 2 of section 5, that the consent of the petitioner or where the consent of the guardian in marriage under section 5 as it stood immediately before the commencement of Child Marriage Restraint Act, the consent of such guardian was by force or by fraud as to the nature of ceremony or to any material fact or circumstances concerning the respondent. Then D says that the respondent was at the time of the marriage pregnant by some other person other than the petitioner. And then clause 2 says, notwithstanding anything contained in subsection 1, no petition for annulling a marriage on the grounds specified in clause C of subsection 1 shall be entertained if the petition presented more than 1 year after the force had ceased to operate, or as the case may be, the fraud has been discovered, or the petitioner has with her full consent lived with the other party to the marriage as husband or wife after the force has ceased to operate, or as the case may be, the fraud has been discovered. I'll be coming to the grounds of this voidable marriage. Basically, I'll just tell you the crux of this voidable marriage. We consider 4 things as with coming under voidable this thing. Number 1 is impotency. Number 2 is mental disorder. Number 3 is consent obtained by fraud or force, and then it is concealment of pre-marriage pregnancy. The last one is concealment of pre-marriage pregnancy. Now, when we talk about impotency is considered to be the first ground of voidable marriage. Before that, I like to tell here that in the case of void and voidable marriage is prospective. It's not retrospective. The section 11 is prospective in nature. In the case of voidable marriage, it is also available to the marriages that have taken place before the commencement of this act. So, it's retrospective as well as prospective. The first ground of voidable marriage is impotency. Now, in a layman's language, normally we usually say that if this person is a barren, that means he is an impotent person or she is an impotent person. If that woman is barren, she is an impotent person. But impotency is not barrenness. It's basically inability to consummate your marriage. If you are unable to have normal sexual intercourse after your marriage, that's basically impotency, and it could be mental, it could be physical. So that means either it could be physical or it could be mental. If you are after your marriage, you are unable to consummate your marriage, you are not able to have normal sexual intercourse, it could be out of your physical deformity, it could be out of your mental abhorrence or mental repugnancy, then the aggrieved person has got a right to move to the court and get the marriage annulled. Now, when we talk about physical impotency, I said that it is of 2 types. Physical is when there is structural deformity. For example, undue large male organs or small female organs. Then, and because of that, you are unable to consummate your marriage. That's a case of physical impotency. There have been a lot of cases where on account of physical impotency, the marriage has been annulled. Then, mental is you have a mental repugnance. Maybe, although it's very difficult to prove that thing, but the circumstance, for example, if you are living, it's a newly wedded couple, you have been living for so many days and nights and you are unable to consummate it, then the thing is that because of that mental abhorrence or mental repugnancy towards sex, that's a case of mental impotency. If they are curable, then you do not have a ground to move to the court, but if they are incurable, either the physical or the mental, then the aggrieved person can move to the court, can annul that marriage. It is necessary that in case of voidable marriage, it's not automatic dissolution. You need to go to the court and get that marriage annulled. If you do not go to the court and you die, that marriage is completely a valid marriage. But for this thing, you need to go to the court and get your marriage annulled. So that's a case of impotency. Again, I have told that barrenness would not come under it. If the person is unable to conceive, you cannot say that that person is an impotent. She might not be able to conceive, but she is able to have, she's very able to have normal sexual intercourse, then it's not the case of impotency. Impotency is relating to the consummation of marriage. Second is mental disorder. I've already explained mental disorder and when I was explaining section 5. I'll come to the third one, that is consent obtained by fraud or force. That's the third ground which is available, and it says that there are certain requirements of this, that the consent of the party is obtained by fraud or force, and after it is taken, the time limit that is given to the party is 1 year from the date of discovery of fraud or cessation of force, and after this discovery is made, you should not go for normal sexual intercourse. So that means if you go for this thing, you have condoned your partner, you have let go this off. So these are certain requirements, and all these requirements, it need to be complied with. If any one of them is missing, then you will have to suffer to your latches and there's no remedy that is available to you. So many times in our old Hindi movies, we used to see Prem Chopra or Pran, they were just getting forcefully married, in the sense they are making the women forcefully married. There's a pistol behind her and she was told that you need not utter a word and you just we'll just have those fairas and all those stuff. Now here, it's the consent. The woman doesn't want to get married, but the consent is obtained by force on account of that pistol you are keeping, and then you are getting married. So that's a case of, avoidable marriage. So there has been so many cases, Rice versus Rice, Scott versus Hebrides. So this thing is not allowed, and it's a case of this thing. Then fraud is another, though there is no definition of fraud that is provided under the Hindu Marriage Act 1955. But anything which is concerning the respondent, which is a material fact and which you have hidden, that will be the case that would be coming under fraud. So in those, if the consent of the party is obtained by fraud, then also the aggrieved person can move to the court and get the marriage annulled. It could be the nature of ceremony. For example, you are having a marriage ceremony and you mislead a person and say that it's a betrothal ceremony. Of course, it's a case of consent which is being obtained by fraud. It could be you are suffering from a serious disease and you are not telling it, would be partner. Again, it's for example, you are suffering from HIV, AIDS or some other serious disease, and this thing has been hidden then and the marriage has taken place. It's a case of consent obtained by fraud. There are a number of issues can be there. It could be concealment of age. The person is very particular that the woman should be younger to him, and you have hidden, and the woman is as good as twice the age of the boy, and you have hidden that fact. Of course, it's a case of consent obtained by fraud. Then maybe the woman was earlier married. There had been a case where she was married thrice and she had a baby also through cesarean, but this thing was hidden from the person. So that was a case, consent obtained by fraud, and this person has got a right to move to the court, aggrieved person obviously, and get that marriage annulled. Concealment of religion or caste. You are very particular that you want to get married to a Hindu only, and that person has concealed his identity, his religion, and later on he turns out to be of some other religion. Then you can move to the court and apply for, get that marriage annulled. Let me tell you, these things are very subjective. It would depend. Some might not have any problem having intercaste or interreligious marriage. But if a person has this ground, but if he doesn't have any problem, that's a valid marriage, he will not go to the court, and that marriage would be completely a valid marriage. The last ground is concealment of pre-marriage pregnancy. And then another thing is that I have forgotten there is that it should be presented within a period of 1 year. 1 year when the act had come into force or the fraud was discovered. Time limit is very important, and after discovery of this thing you should not go for sexual intercourse. If you do not abide by it, your case comes to an end. So that's a requirement. The last is concealment of pre-marriage pregnancy. Here the woman is pregnant at the time of marriage. She is pregnant from some other person other than the husband. The husband is not aware at that time that she is pregnant to another person. If when he discovers this thing, he has this time period of 1 year, and within this period he needs to file a case, and he should not go for sexual intercourse after discovery of this fact. In the cases of marriages that have taken place before the act has come into operation, it's 1 year from the date of that marriage. That time period is an important factor under it, because if you do not go it, then you are losing your case. So that's an important requirement. So that was basically void and voidable marriage. When we come to section 16 of the children, again it's a very issue with the Marriage Laws Amendment Act 1976. It has been stated that children of such kind of void marriage, who are born out of void marriage or annul voidable marriage, they are considered to be legitimate. It has been said that why the children should suffer because of the fault of the parents. Their parents have committed error. Why should the children suffer? So they should be given the status of legitimacy, and this was conferred by Marriage Laws Amendment Act 1976. So these children are legitimate. Recently only there was a case relating to the property rights, and it was in Jinia Koitin versus Kumar Sitaram Manji and Bharat Mata case, Vijaya Ranganathan. It was laid down that the children who are born out of these kind of marriages, they have no right in the father's compulsory property in which he has a portion. But in the landmark case of Supreme Court, Revan Siddhappa versus Mallikarjun, recently only it was decided by the Supreme Court. The court had laid down that any kind of property, whether it is self-acquired or it is ancestral, of which a father has a portion, the child, even though he is an illegitimate child, he has this right. So he has this property right. So children who are born out of these kinds of marriages, although the status of legitimacy has been conferred on them, even in the matters of property rights, whether it's an ancestral or a self-acquired one, where the father has a portion, so these children are entitled to such kind of property. So this was regarding void and voidable marriage. I'll come to an end by this slide, and thank you so much for patient hearing. And in the next lecture, we would be moving further, and we would be talking on section 10 and section 13, and maybe divorce by mutual consent also I'll be discussing under section 13B. So that would be my next lecture. Thank you for patient hearing. Thank you so much.
Understanding oneself, understanding others, understanding society at large, understanding the nature, these are all driven by basic human curiosity. We would all love to understand why things happen, what happens, what is the final outcome, why certain things fail. These are all exercises that we perform in various domains of knowledge. Therefore, knowledge in various domains, you would realize they are actually social artifacts. They have to be rooted into historical perspective, they have to be culturally salient, and there would be socio-political reasons behind this. Whether you talk with respect to engineering sciences, whether you talk with respect to physical sciences, biological sciences, social sciences, that's the reason why humanities and social sciences should be understood by all of us. The knowledge that is segregated, that is divided with respect to areas, specializations, all of them needs to be understood in its context. And what provides the context? It is the social reality. How do you correlate knowledge in a given domain with the cultural reality, with the social reality, with the socio-political compulsions? Okay, how do you understand the law of nature, okay, in its totality? And for doing that, you require the understanding of humanities and social sciences. Say for instance, if you are trying to understand the effect of a particular bacteria, a virus, any microbe, how it affects behavior, how it affects the organism, human being, you start looking at it from a pure biological point of view. If you are trying to look at a particular type of a wavelength, say for example, you are emphasizing on the understanding of the effect of radiation on human life, you are looking at things from a physical point of view. You are looking at the corresponding changes inside the body, you are looking at the physiological side of the understanding of the information. You are trying to understand why, despite knowing the risk that is inbuilt in the process, why still human beings engage into it. You are looking at it from a pure behavioral point of view. Why society at large admire things which has full of risk. You are trying to understand things from a pure sociological point of view. Why people use particular set of words to explain those experiences. You are trying to understand things from the linguistic point of view. So, there are a whole lot of things, and then finally you try to combine all of them to say that what are the guiding principles in life. Then you say you are looking at life, you are looking at humanity from a pure philosophical point of view. And this is what social sciences courses provide you. They provide the context to you in which you would be finally positioning the understanding of the knowledge in any given domain. It could be engineering, it could be sciences, it could be medical sciences, it could be social sciences stuff, it could be humanities stuff. So, contextualizing the knowledge is what humanities social science courses help you obtain.